All right, everyone, welcome back. This is John here with Case Dismissed. I just want to do a quick little update video. I know it's been a while on my car process with the Raptor. So it's taking a little bit longer than I had expected as far as just for the mailings. So my payment was due middle of April, and as you see, today is May 1st, and I just got my mailing from TD Bank. I just tracked my certified mailing slip. I mailed it like 3 weeks ago, and they just barely got it on the 29th. So part 3 was going to be more about their rejection letter and what they're saying and how they're saying it, and what we do next. So basically, I'm still waiting because they just received it. I'm pretty sure the next week or two I will be getting a rejection letter from TD Auto Finance that they cannot accept that form of payment. They can only accept cash, check, cashier's check, money order, blah, blah, blah. The standard response. Of course, they're not going to return the instrument, and they're going to tell me I'm past due and I owe, and that's when I'll give it a few weeks, and then I'll I'll do the CUSIP search for my instrument, and once I get the CUSIP for my payment, then I've caught them red-handed, unjust enrichment, fraud, and send them my notices, and then threaten a lawsuit with them for now that I have proof that they've lied about accepting my payment. And I'll also give them a chance to, send it back. And, of course, they won't be able to do that. And like I said, that's where you go back and forth with them. You protect your car. And in the end, you should get a 1099-C. So that's where we are. Like I said, they just got it a couple days ago. So it'll probably be sometime next week or the week after before I get a response from the bank saying that, hey, we can't accept this form of payment. And then also they'll probably send me a notice of acceleration. That should probably be their next, telling me that they're going to repossess the vehicle. So that's where we are. This is just a little quick update. Just want to talk about some other cases I have going on. I have a case, a third-party debt collection case, LVNV funding. My buddy had a trial a couple weeks ago, and based on our counter affidavit, so we filed the answer with the counter affidavit, and we filed the notice of beneficiary, notice of subrogation. And in the trial, pretty much won the hearing. The attorney had no response to our counter affidavit. The judge questioned the attorney, what is, he needed to respond to the counter affidavit, and or he wouldn't be able to prove his point. The attorney made an excuse that he had just got the case the night before, blah, blah, blah. The judge then is giving them 60 days to come up with better assignment documentation that proves that they, are the proper party to hold the debt, which of course they cannot provide. The original lender is not going to put their name on any assignment documents or signatures, anything. They don't do that. That's the key with these debt collectors, is the original lender gets the loan, securitizes it, which means they sold it to a trust, and once you don't pay them back, then they act like they sold it to this third-party debt collector, which they do, but the original lender doesn't own the documentation anymore. It's been sold off to a trust. So when you do your counter affidavit, it has all that information in there. This is tailored to a LVNV funding lawsuit, which they're all pretty much a standard template. And so we counter their documents with that counter affidavit, and of course a response. I have another process that I might put on here that includes a a counterclaim for $5 million against LVNV or against a third party. I have a case in New York where it doesn't look like the LVNV funding never responded to our counterclaim, so we should get a default judgment for $5 million against LVNV. That's in Pennsylvania. But basically, they can't, and every debt collection case is the exact same, guys. With the purchase agreement, the original lender is not going to sign any document giving them any liability. They're just telling the third-party debt collectors, do what you can to collect it. It's not on us, it's on you, but we're not going to put any liability on us. We're not going to sign anything. So that assignment documentation usually will have signatures from those trust entities to the third-party debt collector. But the previous documentation from the original lender to the trust people or to anybody else won't include their signature. Thus, you can't have valid secondary assignments if the original is not valid. It voids everything. So that's how every case, third-party debt collector case, is. Every single case I've ever seen in my life, that assignment document is fraudulent. And with this affidavit, it attacks that. So that case should be dismissed soon. That case will be won. The case in Pennsylvania should go to a default judgment. It's been 9 months, and they never filed a response. And then another guy in Pennsylvania has another lawsuit from Velocity Investments up in Pennsylvania again. And in that case, the third-party debt collector, their affidavit is supposed to be from a custodian of records, didn't include that. Their affidavit was from the filing attorney, that he is verifying everything in the lawsuit is true as the best of his knowledge. Well, that's obviously not valid. So we are countersuing them for fraud and malicious prosecution, because that attorney knows he is not allowed, per the rules, to be the filing attorney, the attorney representing the plaintiff, and the one signing the affidavit that they're the custodian of records, they know everything's true, blah, 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 blah. It's just another scam. What these debt collectors do is they file 100 lawsuits. They probably get 75 default judgments and probably get 15 other summary judgments. And they have 5 people that fight, and they lose those fights. But it's a numbers game. So don't be one of the first two in the numbers game, the default judgment or the I don't know how to respond, so I either hired a lawyer or just went to court and got beat. So always file a response. Always do your counter affidavit. If you don't put anything in on the record, then the judge can only see their stuff, which means they win. So there's that. And I always file this into every case because I don't want the court to imply anything. So when you put this notice in there, you're noticing the court you're not the trustee. You're the beneficiary. You're claiming all the securities, all the documents. You're claiming everything. So that gives you the right of subrogation. You're no longer the implied surety. You are now the beneficiary. And what I like about this document is there's no codes. You're just expressing what you are. So now the court can imply that you're the trustee. The court has to act correctly. And what I've noticed is every case that I file this in, the court starts acting properly, and they start actually attacking the attorneys because the attorneys are the trustees. The court's the trustee. You're not the trustee. But if you don't let them know, if you don't express it in writing, give them a notice, then the court's just going to imply that you're the trustee. And you notice when people go into court and they argue and they yell, I'm this, I'm that, blah, 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 you don't have these rights. The court doesn't care. What's on the record? Do you have any notices? Have you sent any notices? Well, no. Well, then you can sit there and talk to you blue to your face. And then, 5% of people, probably less, can actually get away with it with talking in court without filing stuff. But in these cases with this, none of my clients ever even bring it up. It's just now that it's on the record, they get treated correctly. And usually the judge attacks the attorneys. So I would advise to, in any kind of civil case, file that document, file that notice, and file your response with the counter affidavit, and go from there. So this is just a little quick update. Not much going on with court cases. They're all just kind of waiting on hearings being scheduled. I have a court case in New York. I just helped somebody file a motion to dismiss. They're getting sued by a lender. And if you look at in these cases, every time they sue you, they always have to include an affidavit. And look at their affidavit. Because in the affidavit in this case in New York, it's written from somebody who says they're the custodian of records. But his affidavit never really says anything. He never really says, they were injured because of this loan, because of their failure to pay, that they defaulted. It's just saying that I am the custodian of records and I am familiar with this, and some stuff happened and here's my signature. Well, we're filing a motion to dismiss based on an affidavit because it was very vague. It doesn't really actually say anything. It's very double speak, lawyer speak. But when you actually read it, it doesn't say anything. So we filed an affidavit, a counter affidavit, motion to dismiss, failure to state a claim. So we'll see how that works. That's in New York. So it's never dealt with New York court. But so yeah, I've got a bunch of debt collection cases that I've won, and currently looks like a couple are about to win. And in my Raptor case, like I said, I'm just waiting to hear back from TD Bank. It's been they've had it for 2 days, so and it's at a PO box. So I'm sure it's going to be a week or two before I hear back from them. I did get a the second bill already that I for the second month, so they're not upset yet. And in that last mailing I got, they don't even know about the payment yet. So that's it, guys. We still have the traffic certificate dismissal stuff here on the website. This is a good one because it has 2 ways to beat a traffic ticket. And if you put this together with YouTube video right here, the bonds, you put those 2 together, you can beat almost pretty much any criminal case. So that's very helpful. I talk about it right here on this video. It's a really good video talking about the whole process. So guys, it's just a quick update here at Case Dismissed. Check out the Facebook, YouTube, go to the website, get a consultation. I've been doing a lot of consultations lately. And on the CUSIP, I've been getting a lot of CUSIP requests. The problem is, guys, don't just, send me a number and your name. I need to know what type of document it is, whether it's a mortgage loan, car loan, who the bank is. If you can include a copy of a statement, that helps, so I don't have to email you back and play email tag. And it just, the process takes 5 to 10 business days to get it in the first place. So if you don't give me all the information, it's just going to take longer. So getting the CUSIP is a very powerful tool if used correctly. Like I said, I've got some free stuff. This is a good document. Put this beneficiary document, this notice, in every civil case. And then, of course, the responding to debt collectors, guys, is pretty easy response. I'm debating about doing another process where you can just get the case dismissed, or file a counterclaim and see if you can get some money out of them. The counterclaim, I usually just use it just to put the pressure on them. Don't want to dismiss the case, and it's worked. I think almost every single time I've done it. The other guys have pretty much told my clients, hey, you dismiss your case, I'll dismiss mine. Usually everyone's happy with that. Get an easy dismissal. But in the Pennsylvania case, they just never responded. And it's LVNB funded. It's not a small debt collector. It's a big name one, at least down here. And they're going to get a default judgment. And I don't see any way around the judge. Not, if a debt collector sues us and we don't respond, the judge gives them a judgment for whatever they ask. It doesn't say, no, you don't get that, blah, 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 blah. You just get the judgment, and with no money. or changes the money amount to smaller amount. So it should work the other way. I've looked up all the Pennsylvania codes. They were supposed to file leave of court to why they haven't filed a response. They never did. So they should get a default judgment. We've requested a default judgment. And default judgments, you can't appeal them. You can request a motion for a new trial. The problem with that is, since their delay was so long, they don't have a valid reason why they need a new trial, because they never filed anything. They filed a response 9 months late, but it didn't address why they were filing so late. So any response they file is, by Pennsylvania rules, is void. And since no leave of court was requested, no valid reason, and they're a big corporation, so we'll see how that goes. We should be getting default judgment for $5 million in that case, and if that works, yeah, I'll definitely put that counterclaim in here. Let me know in the comments if you guys would want that kind of template. Of course, it'd just be $10. I like to do all these templates $10. It's just easy. Guys, any questions? Feel free to hit me up on Facebook Messenger. Put a video or put a comment on these videos on YouTube. Check out the website. Email me, admin@casedismissed.com. And have a great rest of your week.